The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Everyone, please be seated. We are here this afternoon for the submission of 3 cases. The case of Benjamin Train versus State of Iowa is hereby submitted without oral argument. Our first oral argument of the afternoon is Dr. Diercks and Diane Holst versus Scott County, Iowa, and Carrie Tompkins. Looks like the parties are ready. Mr. Meloy, you may begin. By the way, it's my understanding your yellow light will come on with 1 minute left, but we'll put it back to the typical 5 minutes for opposing counsel. Okay, thank you.
Good afternoon, Chief Justice Christensen, Justices of the Iowa Supreme Court, Counsel. This underlying lawsuit was tried in equity. Therefore, there is a de novo review by the Supreme Court in this appeal. Under Chapter 22 of the Iowa Code, there's a basic premise in favor of disclosure of public records. There is actually a presumption of disclosure. Any ambiguity in the act is resolved by the court in favor of openness. Now, the facts central to this case are not in dispute. The district court erred when it relied upon the 1988 Supreme Court case, City of Sioux City v. Greater Sioux City Press Club, and I'll refer to that as Press Club. Press Club held that job applicants for the position of Sioux City City Manager could be kept confidential under 22.7. Press Club is clearly distinguishable from the present facts. Press Club pertain to employees applying for a job with a government entity. In the present case, we're talking about candidates who applied to be a public official, Scott County Supervisor. A Scott County Supervisor is not an employee of the county. A Scott County Supervisor is the employer for the county. You can look at Chapter 331 of the Iowa Code, where the legislature granted sovereign immunity to counties, specifically supervisors who are the highest ranking public official for a county. So therefore, both the county and the district court erroneously relied upon the Press Club case to find that these candidates for public office were employees of the county. That's simply erroneous. If you look at 331 and the unrebutted affidavit of plaintiff Diane Holst, who was a one-year term county supervisor, Ms. Holst lays out the differences between an employee and her position that she held for 4 years as a supervisor.
You're only, Mr. Meloy, you're only asking for the names, correct?
Correct.
Under your logic, would you be entitled to any materials that they submitted in support of being appointed to this position?
It would depend upon what the materials were, Justice. Are you talking about the resume? I believe the resume would be a public record. Obviously, their social security number, any identifying information regarding their address possibly could be held confidential under the Rippinger opinion made by this court in 2021 that was authored by Justice Waterman. So, we asked primarily for the names of the candidates.
Had a cover letter saying why they were so great and should be a appointed supervisor. That would also be something that should be public? Yes. Okay.
Are you asking for the resumes and cover letters in addition to the names, or just the names?
We asked specifically for the names of the candidates. Justice Mansfield asked about what else might be public. I believe that a cover letter and a resume would be part of the public record also.
The Teague case, T-I-E-G, that came out after your briefing, for the same reasons you distinguished Press Club.
Well, in Teague, you had applicants for the city attorney position in Cedar Rapids that the plaintiff was seeking. And the court, of course, under Press Club, held that any applicants that were outside of the government were protected by Press Club as confidential. If there was an internal applicant who applied to be city attorney, such as an assistant city attorney, then that would not fall under the confines of Press Club. So you made that distinction, of course. You reinforced the distinction under Press Club in Teague this year in 2024. And of course, Justice McDermott's 2024 opinion in Kirkwood Institute clearly held that under 22.718, there is a reasonable belief standard that is objective. That's the objective standard based on the public records custodian's belief. And we believe the court erred under 22.718 in finding that the custodian in this case, the defendant Scott County Auditor Tompkins, could have a reasonable belief that these names were confidential.
I have a question for you. So you're kind of hanging your hat on the fact of a distinction being that this is for an elected position, a very public position, compared to being an employee. Is that correct? That's why Press Club, in your opinion, doesn't apply. I have not done as much digging as I could yet, but I found one statute, and it's not relevant to this case, but it makes me wonder, are there other statutes where the Board of Supervisors are specifically dealt with as employees? It's 97C.2. It's a federal Social Security Enabling Act. But it says right in there who is and who isn't, who's in, who's out. But every member of a county Board of Supervisors and every county attorney shall be deemed to be an employee under this chapter. It just got my attention because obviously there are times when it's not so clear. Are they an employee or not? So a Board of Supervisor, can you address that? Do you know of any other statutes that would be similar?
Cited three of the federal statutes in our brief: the ADEA Act, the Fair Labor Standards Act, and the 1964 Civil Rights Act. Also under State Code, Section 670.4 draws a clear distinction between an employee and an official. The two words are joined by the conjunctive "and," meaning that they're separate entities or considered separate classifications. We've also submitted the unrebutted affidavit of Diane Host, where she goes through a litany of powers that a supervisor has. Supervisor cannot be fired by anybody in the county. The supervisor is the employer. The supervisor passes the county budget, passes ordinances, resolutions, motions. They appoint a myriad of citizens to a host of different boards and commissions. Their salary is not set by the county, set by a separate compensation commission.
Ask you another question. The basis for Press Club, if I have it right, is the exception in 22.7. It's the number 18, right, that says. And really the analysis in there, I don't think is about, in the language of the statute, is really about employee versus non-employee. It's more about persons outside of the government to the extent that the government body receiving those communications from such persons could reasonably believe that those persons would be discouraged from making them if they were public, right? That's the concept?
Concept, Justice.
So I wonder if there might not be a reasonable reason to think that some applicants for this position might not apply if their name were public from the outset. And I realize it'll be public eventually. That's your point, is that this is obviously a very public matter, but like with U.S. magistrates, for example, their process starts out private, and you can submit an application privately, and that probably encourages some people to apply that might not otherwise. Am I off the base on that?
I think that you have to realize, again, that Press Club dealt specifically and only with the confidentiality of employee applications. And under 22.7 of the Iowa Code, once we prove the 3 tests, there's no question Scott County is a government entity, number one. There's no question that these electronically submitted resumes are public records, number two. And there's no question that the government here, local Scott County, refused to provide 13 of the candidates' names. So now you have the shifting burden of proof enunciated in Justice Waterman's, I believe it was the opinion. And now the burden is on the county, not us. We don't have to prove anything else.
I guessed that because that was exactly where I wanted to go. So if the Ripperger case says we're supposed to objectively make a decision whether or not the custodian made a reasonable determination, and you're right, this is de novo on a case of inequity. If we're utilizing that test, why should we overturn the record custodian's decision? Although we are de novo, it would make sense also to take into consideration the findings of the district court.
First of all, there's no reasonable expectation of privacy when a candidate for public office submits a resume to be appointed to that public office. In a parallel situation, if I run for office, if you run as an elected, as a candidate for office, you cannot keep your name secret. Run. That's right, but once they're appointed, they may be in the elective office, and they will be running if they run when their term's up.
You run for office, you're going to be out beating the street, knocking on doors. Your neighbors are going to know what you're doing. You're going to be on a ballot with the name of Susie versus Tom, and until neither one knows who's going to win until the election is over. But in this appointment process, that's not true. That decision, nobody knows who it's going to be, and I don't understand why it's understood that it's public. That's why there's a different path. And which I want to ask another question before we run out. It leads into that. There was another path that the board could have taken, which is special election. It could have asked for it itself, or there could be a petition. Is that correct? Was there ever any indication that that was a path they were going to take?
No, there was not.
Could it have still happened during this process? Because we were...
This process, if a petition by the voters had been filed requesting special election. I want to follow up on your comments. Second, by submitting their resumes in this case, each candidate implicitly consented to the release of their name. When they actually submitted their resume, they made no request for confidentiality. Only
released. They didn't explicitly say that. They weren't asked if they wanted to keep it confidential, and they didn't demand it.
they were asked by the defendant county auditor when she said, please advise if you want your name confidential, after the applications were in hand, did they, 13 of them, state they wanted confidentiality? Now, so they were prompted by the county auditor on whether they had confidentiality. If you look at the county's brief, and remember, the county cites one case, Press Club, in support of their argument here. That's their sole case authority. When you look at their brief, they say that confidentiality attached automatically to these resumes when they were submitted. That's not correct. That's an erroneous statement. And I want to go on to another point here before my time expires.
A statement.
Because confidentiality does not attach automatically, they didn't request confidentiality, and this is involving a public official, and public officials' names are a public record. You can't hide the names of a public official.
Public officials until they're appointed to the position. That's correct. So why couldn't somebody apply for one of these with an expectation of privacy that the application wouldn't be revealed unless they were successful? For example, university president searches.
I don't think it's objectively reasonable for a candidate for public office to believe that their name can be confidential when they apply for that office. I think if you look at the affidavit of Carrie Tompkins, may I finish my question? My time is up. Finish my answer. The affidavit of Carrie Tompkins says one thing: I am employed as auditor of Scott County. She never says she had a good faith, reasonable belief and how she arrived at that. They failed their burden of proof here. We didn't have to prove.
A question, when you say she didn't state why, doesn't Section 18 say that to the extent that the government body receiving that information reasonably believes people would be, so it's we don't care so much what she thinks, isn't it what the receiving entity believes?
Custodian's reasonable belief, I believe, under Kirkwood Institute and Rippinger. Thank you for your time.
May it please the court, and I apologize, this is my first time here. This is not my normal format, so if I seem a little nervous, it's because I am. I guess basically I would just start with the fact that the county believed that the names were confidential under that 22-718.
And about the names, were those names disclosed only to the committee, or was there anyone else in the county that had access to those names?
It would have been the committee, specifically Carrie Tompkins, the auditor, would have received them because she's the one that was taking the resumes in through the auditor email. And then the other members would have, the other two committee members, but when it was discussed on how they would be handled, then the numbers were assigned to each person. So until the records request came in, then I don't believe anybody else did, but at that time.
You know, because, I mean, I'm thinking how I think it works here, because I live around here. I think maybe the names are disclosed, and then people have the opportunity to weigh in on the candidates. So I'm wondering, at least internally, whether the committee could hear from, say, other sitting supervisors what they thought of these candidates.
That's not how it was done here. Now, I've only worked for Scott County for about a year, but that they only discussed them amongst themselves, that they looked at applications, assigned numbers, and then discussed them in the meeting.
They didn't, like, no, you know, let's say Ms. Tompkins wouldn't have, like, gone out and talked to anybody and said, what do you think of this candidate prior to the meeting?
That I am aware of for this particular committee appointment.
Process. There are some states that have a statute that says these remain confidential or whatever, they address it. And here we are kind of trying to figure out how to manipulate or interpret the facts and the situation. When you say that we kept it confidential and we assigned people a number, that seems really weird to me. I used to be on a school board for many, many years, and I know how hard it was to get closed session, and we took it very seriously. Seems to me, from my perspective, that what the committee was trying to accomplish was a closed meeting in public. I mean, they called them by number, and so it seems kind of odd. Was that an attempt to get around closed meeting? Was there ever any effort to ask for closed meeting? Do you think they qualified for closed meeting? Because it seems like they did a faux closed meeting.
There would have been an opportunity to have requested that it be done in closed session. That wasn't. It was through the suggestion of my predecessor that because they had requested confidentiality in their names and their information, that they be given numbers. And that's in the appendix that was submitted. That was Mr. Cusack's recommendation to maintain the confidentiality, was to assign numbers even when, and I believe in the letter even it said, this could get a little awkward, talking about people by number during this process, but it was at his behest or recommendation that he suggested they be assigned numbers.
Applicant request confidentiality on the front end before there was a public records request? And was confidentiality promised to any applicant before the open records request?
I'm not positive when, like, time-wise, the emails were sent to the candidates asking if they wanted confidentiality and how that coincided with the records requests, because they were done so close in time. But I believe that they were asked if they wanted the records to be confidential prior, obviously, to the 26th. But I have not seen the emails where they've requested the confidentiality, so I don't know the timing.
Asked if they wanted confidentiality after Mr. Meloy had sought their names?
Prior to that, because there's the letter from Mr. Cusack who suggested that moving forward in this process, that they should be confidential, and so you should, perhaps moving forward, get their consent. Or not, excuse me, consent.
Argument that I think it's made pretty well in the amicus in Mr. Larson's amicus. He says, well, if there was a special election, obviously everybody would remain public and the public would weigh in on all the candidates. So this is intended to be a substitute for a special election because special elections are expensive and not a lot of people vote in them. So instead you have a committee that's making the decision, but it's sort of a public trust they're given. I mean, they're not just supposed to pick whoever these three people, privately in their own cocoon think might be the best thing. And so it ought to be open for people to weigh in on these candidates by contacting the committee. And that makes it impossible, right, when the names are confidential, doesn't it? You can't say, like when I applied to be a judge, people could write in and say, they think I'm good or they think I'm not good. That would be fine. It makes it so it's a very closed process, right?
Looking through it, I don't know that I love that process being available because it's very different from everything that you see when you're going to go through an election. Like we've stated, I couldn't imagine anyone even attempting to go through an election and keep any part of them running confidential.
Piggybacking off of that, okay, once this process started and the Board of Supervisors said out loud, we're going to just have somebody appointed, and the time starts ticking and they put out the notice, there were 2 FOIA requests made asking for the names of the applicants who did not request confidential provided. I think that was the second plaintiff who asked for that. Anyway, that was denied. There was a second one later. Okay, so at that juncture, help me understand, could the plaintiffs at that point said timeout on the appointment process and hurried up and started, we want special election? Once they knew they were getting stonewalled, is that possible? I'm not sure. I don't know from the statute. You probably know it better than me. Once one process begins, can the other one take over?
Would have had to wait for the appointment process to be concluded, but then they could have requested that special election, I believe, within 14 days following the appointment.
What is that process? It seems like if within 14 days after publication of the notice or within 14 days after the appointment is made, a petition, if it's filed, then you have to follow the special election. So what was the date of the publication? Was that January 5th date?
Publication wouldn't have been the 5th. I believe it was the 10th. Don't quote me. I know it is in there. The 5th was when the meeting was held to determine that they were going to use the appointment process.
5th or the 10th, there could have been a petition that was filed within 14 days, so the 24th, if the 10th was when it was filed, the 24th, and they were selected on the 26th, right? So that special election process could have either stopped it in its tracks, or it could have happened even within 14 days after the appointment. Is that how that statute works?
I've not had a lot of experience with that specific statute, but I still, even if, I don't know that it would have stopped that process, but it would have triggered, I think, that then they would have had to do the special election.
Of that process affect whether or not it was reasonable for the county to believe that people would not want to submit their names if this was still a possibility, even after the county had decided to go the appointment route?
Sorry, could you ask that again?
The county decided to go the appointment route, but even after they decided that, there was still a possibility of a special election. And so given that possibility, does that affect, when we're looking at whether or not the county reasonably believed that people wouldn't want to submit their names, how does the possibility of there being a special election affect the county's view that people were not going to want to submit their names if they knew they were going to be public?
The county, and specifically Tompkins and this committee, wouldn't know for sure that a special election was going to occur, so they're going based off of the recommendation of the county attorney, which they requested. If it turned out that then the special election was held, I think that the candidates and everybody would recognize that at this point there's no way for it to not be public. But prior to that being triggered, I think that you have to follow the language in 22-718.
Had the county ever had one of these appointment systems before in terms of supervisor?
I believe it was in 2006.
Instance, did they keep the names of the applicants private?
So.
This is why I asked you that question earlier about, to me it seems it's one thing if it's all kept within the bubble of these three people, but I just have trouble believing that they would do that, because if I was serving on one of these committees, I might want to go and ask somebody and say, hey, do you know this person? Do they come to meetings? How are they, are they active, do they do a lot of volunteer things? Are they willing to donate their time on evenings? And are they willing to take phone calls from the public in the middle of the night? All those burdensome things that you have to do when you're a county supervisor. And I just have trouble believing that decision, that evaluation was made entirely, internally. And if they talked to people on the outside, shouldn't the information be public?
Mentioned to them specifically, Mr. Cusack said, be very careful that any conversation you have about these candidates, even amongst each other, it would be public record. And so they only conducted their own discussions amongst one another during the open sessions. And again, I've stated, and this is just my opinion, that I don't love this method for a Board of Supervisors position. It does feel like none of the trademark things that you have with an election are present here, and that's concerning, but this is a process that's available, and it wasn't an election, and there wasn't a requirement to take public comment or public input on who to select for this position, and I'm not saying I agree with that, and I don't, the county, since this has occurred, has, discussed that in the future, are we going to do something more akin to the judicial applications and state on when we're presenting them, if it's an application, for instance, do we say that this is going to be publicly disclosed? Because that would remove some of this anyway, ahead of time. Now, yes, that may discourage some people from applying for these positions, but then we wouldn't be here today. But again, hindsight's 20/20, and we're looking back on it, having not gone through this previously, and we can only work to improve what we're doing moving forward. So I do know that we've had conversations, I personally have since I took over this position, about making things more transparent. But again, I'm limited to the decisions that were made in the record.
Agree, as we apply the statute, shouldn't we err in favor of openness and transparency?
I think that is generally, we discourage exemption, but there are over 70 exemptions. And I do think that this plainly fits in there. I think press does apply because, as Justice Christensen mentioned, these people aren't employees. They're not public officials. They're nothing. They have no status other than a private individual. When they made these applications, for lack of a better of, when they submitted their cover letters, when they submitted their resumes, when they gave their names, they were private citizens. There's no doubt they were outside of the government because we had no internal employees. I verified that with 2 separate people. There were no internal candidates. There was one man who previously worked as, I think, a golf pro at one of the golf courses, but they don't have a status until they become that official, that employee. And that's why in my brief, and I stated, and my predecessor said, I don't know that whether or not somebody's employee, an official, whatnot, is as big of a deal as it's been made out to be, because they are none of those things at this point, and they're not being elected.
Now apply equally here that some candidates may not want their current employer to know they're looking around, and you likely will have a deeper applicant pool to choose from if you have confidentiality at the initial stage.
And I think what's failed to be recognized by opposing counsel is, you know, a lot of times people for these positions are self-employed. They're oftentimes attorneys, they're financial advisors, they're the retired persons. And they may have a different thought on how their application could be perceived. But somebody
who's looking to switch jobs, I mean, that's usually a concern. You don't want to offend the people you work with. You don't want to, I mean, if that's the case, then I think nothing would ever be public as far as applications. I think most people who are applying for a new job would love to keep it quiet, because if you don't get it, kind of embarrassing.
You know, the 27 people applied, 1 person got it, but 14 people allowed the information to not be confidential. Looking at that list of names, I know some of them, and most of the ones I know are self-employed. The distinction I make is I think it would be a little bit different for somebody who works at Costco or a bank or as an hourly employee for their employer to find out that, hey, I'm applying for this job that for some intents and purposes it is part-time, but you cannot control, you don't get to decide when the meetings occur, and that would impact their employment. And we can say that your employer can't use that against you, but how are we to know what decisions or what an employer's made those decisions based on? So I do think that that's why it so clearly fits in here that we all don't make our own schedules, and
Arguments looking in the rearview mirror. But I think the questions we want to know is, when people were submitting their applications, wouldn't it have behooved the county to have had all of those things up front? Hey, people, this is going to be a confidential process, or it's not going to be, but to leave it open-ended and then ask after the fact?
I think it's a little bit curious how it was done, because it was just, hey, send your materials here, send these 2 things, and it wasn't necessarily a job posting like you traditionally see, or a lot of information given, like when you apply to be a county attorney, a city attorney, another county employee. So yes, in a perfect world, that would happen in the future. We would include that, or as I discussed, hey, look, we've determined that we're going to have these things be public. And that would have been helpful, but this process wasn't one that's followed traditionally. They had a lot of leeway in making their decisions on how they were going to run this appointment process, and they chose to say, we're publishing, and we just need a cover letter and a resume. And so it was published in the paper, and I guess, yes, in hindsight, they could have put something in there about the confidentiality.
Mr. Meloy, and while you're walking, you get to listen to my first question, because I'm going to piggyback off what she just said. If that is the history of Scott County, and I think Justice McDermott asked a question, and she said, like in 2006, there was something similar, and she believes the names were kept confidential. If that's true, wouldn't that be an indicator of local history, that there would be an expectation of privacy?
First of all, Chief Justice, I don't know if that is true. Secondly, simply because they committed an error 15 years ago does not allow them to repeat that error today. This was a 2023 situation regarding the applications for appointment to this office. I want to answer Justice Oxley's question that she posed to counsel. The date of the public notice was not January 5th. It was not January 10th. It was published on January 18th, 2023. 8 days later, this committee met and appointed the candidate by number. Number 16 was picked. So the public who were attending that meeting, including plaintiff Diane Holst, didn't know who was actually being appointed at that time until after they announced, after the meeting, who number 16 was.
Of dates, and where do those FOIAs fit?
FOIAs were made on January 27th, 2023, and January 31st, 2023, after the appointment was made. And if you look at their response, they even withheld the person they appointed on their official disclosure. They didn't even disclose her name to us. They never gave us her name as a public record or her resume.
FOIAs were filed after appointment. My experience with FOIAs is there's oftentimes an informal request first. Hey, hand it over. They won't. Hand it over. They won't. So you file something. Were there informal requests made that are in the record?
Can't answer that question whether they were informal requests. What I do know
is I assume that the plaintiffs started smelling a rat. Couldn't they have gone down the path of 69.14A, which is special election, and all of this would be hooey?
that was also a possibility. Even after the appointment was made, there still could have been a special election. And you have to realize the short time frame of this appointment being made when most people didn't know any of the candidates' names. They had no opportunity to scrutinize or to comment yes or no or pro or con on any one of these candidates. And the appointment was made by number 16 after 8 days of the publication of the notice. Now, all these candidates had to know that this was also subject to a special election. So if there was a special election, then they would have to run as a candidate publicly for office. And
but I am very interested in the special election issue. Now, let's say that somebody did start pursuing the special election right within the time frame. Nobody's going to complain about the time frame. Those old FOIAs, we might not get the same people to actually put their names on a ballot. What is your position on would they ever be able to obtain those names of people who applied the informal way, and then once a special election was called, maybe only 4 people wanted to be on the ballot?
I believe, as I've already reiterated, the government never met its burden of proof to prove section 22.718 applied. They had the burden to show these were confidential. We didn't have to prove they were confidential. They're assumed public under the state statute.
Court comes down that, yeah, they satisfied that burden. Okay. I want to know more about the special election. Where would that ever fit in? Can it fit in?
My understanding is that pursuant to Chapter 69 of the Iowa Code, the special election could have been called after this appointment was made by the voters of Scott County.
It would have to be gathered to get a special election by petition.
I believe it's based on the balloting in the last election. I believe it would be probably somewhere between 500 and 1,000 signatures. That would be my estimate.
Let me ask you. I asked Ms. Lyon about this. As I understand, she has no reason to believe that any of the individual members of the committee solicited input on any of the candidates from anybody else during the time leading up to this public meeting. Is that your understanding as well?
I don't know that, Justice. What I would point out to you is that I would think if that was important enough where she was claiming that, number one, that sounds highly unlikely to me. But number two, if that was the case, she would put it in her affidavit that this matter was confidential between the candidates.
Is that if anybody can weigh in on these candidates, then outside the committee, then maybe the public ought to be able to weigh in on them.
We don't know if these candidates talk to their neighbors, their friends, other public officials about making the candidacy, asking, hey, I'm applying for Scott County Supervisor. I hope you can possibly put in a good word for me with the county auditor, the county recorder, the county treasurer. They're all elected officials. The public talks to them all the time. I just want to sum up my argument by saying the district court further erred when the district court shifted the burden of proof to plaintiffs to prove a compelling reason that these were not employees of the county, these candidates. There is no requirement under Chapter 22 that we have to show a compelling reason for the public record.
The order said, didn't the order just say no evidence was presented that any of these people were employees? You could be right, but I thought my memory served me that Judge Latham said evidence was not presented.
I'll quote from the order, page 4 or 5, the district court order. The plaintiffs have not provided a compelling reason to believe applicants filling this vacancy are not employees. As such, the information of the non-consenting applicants cannot be made available.
Splitting hairs there. I think that kind of says what I say and what you say, a little bit of both. Any more questions? You can sum up.
Sum up, we request our Supreme Court to reverse the district court's grant of the cross motion for summary judgment by the county on the names of candidates for public office, and to grant plaintiff's motion for summary judgment in this case, remand this case back to the district court for further proceedings, including injunctive relief and an award of attorney fees under the Chapter 22 fee shifting statute. Thank you for your time and attention today.
County, Iowa, and Kerry Tompkins is hereby submitted. We're going to leave the bench for just a couple minutes to allow the change of attorneys, and the next case will be Belhack versus Smith and others.